case briefs, and so much more. LSData's got what you're looking for.
In the 1960 Minnesota Supreme Court case of Baehr v. Penn-O-Tex Oil Corp., the dispute concerned unpaid rent for gasoline filling stations. The defendant had bought Webb Oil Company, inheriting accounts receivable, which included rent owed by the plaintiff's filling stations. Despite attempts by the plaintiff to contact and receive payment from the defendant, no communication or payment was given. The plaintiff subsequently won a lawsuit for unpaid rent in district court, but the defendant appealed. Examining whether the defendant had possession of the leased premises or an assignment of the lease, and if there was consideration for a contract between the parties, the court focused on upholding the idea that contracts are only enforceable if both parties agree voluntarily to exchange something of value. During this time, the defendant had collected rents and installed an agent to run the business, informing the plaintiff he would be paid. However, when the plaintiff inquired further, the defendant denied responsibility for rent due. Ultimately, the court ruled that the defendant was not liable for rent, as they lacked possession of the leased premises and assignment of the lease. Furthermore, there was no consideration between the parties within a contract, and the defendant was not obligated to pay rent to the plaintiff.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.